we have received a couple of questions. So one of the first questions was, if I have properties in different countries, do I need to have a will done in each country, or should I account for all these different kind of properties around the world in a will?
No, what you can do, it depends on the situation, because sometimes what I face, because obviously I cannot talk about the other countries' jurisdiction rule, what do they follow, but what I have done in my practical life, what I have seen, like someone who lives in India and he has some property and he wants to make a will. So what we advise to our clients, ask your advocate to make a will, prepare a will, and then we are the people who sign it. Like the will has to be signed in front of the witness. So witness, we become witness, we certify that yes, the person who came to in front of me, and we confirm that he signed in front of us. This is how it works. But obviously we can talk about the UK will, but obviously it is not possible, because every country has a different rule and law how the will should be executed. But the answer is yes, it is possible. You can make a one will if the country allows you. But generally what I have seen, like someone who lives in the United Kingdom, but he wants to make a will of the property of wherein he is in India. So the will should be drafted and it should come to us, and then we witness it or we certify it. Yes, he signed in front of us. This is what we can do. Thank you very much.
Fantastic. Thank you for that answer. So another question was, do I need to have my will registered with anybody, or just have it signed by the solicitors? So
it has to be signed, but no, you don't need to register it. But yes, there is a registry probate office where you can send your original will, the probation department, where you can keep your will, but you don't need to register it anything. All right, because if there's a chance that after you date it might be lost, or someone might steal your will because he's not happy with your will, someone might steal it, destroy it. So it's better, it is advisable that there's a probate registry office in Holborn where you can send, and once you send your will, the original will to them, they will give you a certificate. Okay, so that is called certificate of deposit. So you can keep your will like that, but you don't need to register it anywhere.
That's a very good, helpful point. Thank you so much, Mr. Mufti. The other question, sorry, as you were talking right now, it just crossed my mind, was what about if you mentioned earlier having your will with someone, and that person is a friend of yours, and that person passes before you pass, and they're holding your will. So in order to issue a new will, do you need to go to that person's house, find your old will and destroy it? Or
Yes, that's right. You have to ask that person to give me the will back, and he will give you back, and you have to destroy.
No, but what if they're dead? So what if the person? So I wrote my will with, and I've left it with a friend, and that friend died.
So what is the best way? Because if you want to make another will, so in that will, the new will, you will tell that all the will that you have made is invalid. If you write it down in your new will, then it's fine. But if you can get the will and the person is dead, even if still you found the will, you should destroy. But if you can't find it out, that's okay. But you should write in the next will that you have you do not agree with other wills that you have previously done. So all the previous will you have made is invalid. That is not applicable. There's a wording, legal wording, that you need to write it down in your new will.
Fantastic. Thank you so much, Mr. Mufti. In terms of the change of circumstances, a question was, do I need to report things like getting divorced?
Yes, that's another concern. That's another concern. Like, this is the situation. Actually, you are very right to ask these questions. That is very applicable and important here. When do people want to change their will? Like, say, for example, you made a will and you have said to your spouse, or you want to give half of your property to your spouse. Now, that is possible. You no longer have a relationship with him or her, so you divorced her. So now you're not happy to give her 500 your property, or you don't want to make her as a benefit. So you change of circumstances has been done. So you have to prepare a new will.
That's very helpful. Thank you. Another question is, what about the ready-made wills online, where you fill out an online will that's ready-made, and then you can have it accustomed to your situation? Is this valid?
That is a valid, but it doesn't cover all your intention that you want to do. That is why we advise you. It is completely okay. There's no issue on it. Legally, it is valid if you follow the rules, right? And if you follow the instructions. But there is some other things which is more concerned. Like someone might say, someone might challenge this will because some beneficiary are not happy with the will, so they might challenge it. Okay, like the way that I gave you example, like if the format will is in English, right? And the person who make this will, he doesn't understand English or he can't speak English, but he made a will. Someone made a will and he signed it. And now what will happen? The person who get less benefit or who didn't get any benefit from the will, he might challenge. Look, the person who died, he doesn't understand English. So how do you expect that he will make this will? So this type of problems you might face. But as long as if it is a simple will, yes, you can follow. If you're happy with the contents of the will that you can buy from the shop, there's a format you can buy from the shop. Even if from the online you can buy it, you can fill it up. It's up to you. But as long as you have provided follow all the rules of the will, it's completely okay.
Fantastic.
Thank you.
So another question is, this is slightly an immigration/will
Yeah.
writing question, which
Yes.
is if people have a marriage certificate from another country that hasn't been registered in the UK, from what I see, does that make them legally married partners in the United Kingdom?
Yes, the answer is yes. If someone married outside of the United Kingdom, right, they will be treated as a legal married in the United Kingdom.
Fantastic. And the last question for me before I hand over to my colleague to ask you some other questions that they have is, what happens to children under the age of 18 if the parents die and have left no will?
Right. If this is the same, this is called intestacy rule will apply. But in this case, if there's no will and the person died and they have under 18 children, so what will happen? Either court will select a guardian, which is called legal guardian, from the family member if they're interested. If no family member is interested to be legal guardian for them, then the court will opt out someone from their system, like who will be the person who will be responsible for the legal guardian. Or sometimes the court give a duty to the council. The council people, they do take over the children's responsibility until they become 18. So this is how it works in the United Kingdom.
Fantastic. The very last question for myself before I pass it over is, do the beneficiaries have to be in the United Kingdom or can they be abroad?
They can be abroad. If it is a property for the abroad, they are fine. But obviously, if someone who lives in some other country and he can't come to the United Kingdom, but we are giving property from the United Kingdom, there will be complication will arise, because the person who doesn't have a legal status in the United Kingdom or who can't come in the United Kingdom, then there's a very likely that the matter will go to the court and the judge will decide how it will be done or whether it will be possible to done or not.
Fantastic. And do I have to specify that I want it done according to Islamic Sharia, or can I say I just want it done in Islamic Sharia, or do I have to say exactly what I want the split to be?
It is very advisable, because if you say Islamic Sharia, there is some other problems as well, because there are some different school of thoughts. Shia people, Shia, Sunni, Al-Hadith, their school of thoughts. Look, there is little different explanation of how the property will be divided or inherited. That is why it's better to clearly write it down what and how much you want to give according to the Islamic will, according to Islamic theory. So when I say Islamic theory, Surah Nisa have stated in Ayat 11 how the property will be split among the children or to the family members. It should be clear. Thank you.
Fantastic, thank you. I'll hand over to my colleague who has some questions that they've collected as well.
Thank you very much.
Thank you, Mr. Mufti. It's clear that's very interesting and it's a very critical topic that we have received few emails on different platforms here on different Facebook pages. But before moving to the Facebook pages, I have here some people raising their hands and I'll let them to ask their questions. I'll start with Amira Mills, please. Can you ask your question, please? Amira, can you ask your question, please? Okay, so I will. Amira, you come.
Oh, hello. Can you hear me now?
Yes, I can hear you.
Oh, lovely. Okay, thank you. Sorry about that. It was on mute. Very interesting. Thank you so much. My question might be slightly behind setting up a will. It's about the inheritance tax, if I may. And I know that between spouses, the inheritance tax sometimes is not sort of granted, but between when you sorry, can you?
Sorry, yeah, I can hear you, but I want to say you something. The inheritance tax is all about mostly the accountants who can help you out, or the tax lawyer can help you out. So I'm sorry, I cannot give you any specific answer about the inheritance tax related answer. I'm sorry for that. My apology.
Lovely. No problem. Thank you.
Thank you.
Thank you for that. We have Ruwaida. Have you asked your question, please?
Yes, thank you very much. So I just wanted to ask, my husband and I, we got married in Egypt, and we have a marriage certificate from Egypt.
Mm-hmm.
In case one of us, passes away, then are we treated as unmarried? Is the other one treated as unmarried partner? Do we need to register something here in the UK?
No. You don't need to register as long as you register marriage in your own country or any country of the world, right? And you have a marriage certificate. The marriage is automatically granted by the United Kingdom. So you don't need to register yourself again to anywhere else. Thank you.
Okay, thank you. We have another question from Mohammed, please. Mohammed Mahmoud, please.
Yeah, hello. Thanks, Walid and organizer. So I got the question really. First question is about executor. I believe it's better to choose it from the UK, but can I choose one from the UK, one from outside the UK?
No, we are talking about the United Kingdom wills system. How does it work? And we are talking about the property of the wills, mainly about the wills, mainly about the United Kingdom. I understand that you can do some wills, property beneficiary to the outside, but I will advise.
No. I'm talking about UK wills.
UK wills. So if it is the UK wills, it is advisable to do it. It is not advisable. You should pick someone who is United Kingdom, because if someone who is outside of the United Kingdom, it is not possible to execute the will for him or her.
Okay, so it's advisable or mandatory?
It's a mandatory. It's
mandatory to choose executor from the UK.
Yes, because otherwise that invalid will be because it is not possible for someone who is outside of the United Kingdom can execute the will of the United Kingdom. Straightforward.
I mean, for example, can I choose my brother to be executor who can just come and apply for a visa, or it's gonna take time? And
no. You should pick someone who is from the United Kingdom.
Okay, and when doing your will, talking about beneficiary, and say, for example, if you want to give some of your assets to your brother and father as per Islamic law, how are you going to apply this when doing a will if they're not living in the UK?
So you want to give the property to...
Part of it, no. So basically wife and kids are here, but the rest, as per Islamic Islamic law, there, some of the assets should go to your father, mother, and brothers.
And who they don't live in the United Kingdom. This is what you meant, right?
Yeah.
All right. So yes, that is possible because your executor are theirs. All right. Your executor, what will happen is that what generally happen in the probate, it's called probate actually, how you can execute. So in the probate, like they will sell your all property, and according to your will, whatever the beneficiary is, like say for example, according to will, you want to pay your father £20,000. So he will transfer 20,000 pounds to your father who lives in outside of the United Kingdom.
Should I specify the money or the percentage of the...
You can specify the money, you can specify the percentage, or you can specify that from that property, I want to sell, I want to give this property to my father. So what will the executor will do? Executor will sell this property, and whatever the money he get from that property, he will give it to your father.
Okay, thank you. We have Mahmoud Sama, please. Do you have a question, please? Mahmoud?
Yes, hi.
Hi.
Are you hearing me?
Yes, we can hear.
Yeah, I heard like about that some governments like take 40% of the property of that after death. So isn't that, or like it's like a fake news?
This is no. You're right. But it's all about the inheritance tax and this whole thing. So as I advised to my earlier questioner who wanted to ask me a question about inheritance tax and this whole thing. So what I want to explain to you, I'm not inheritance tax advisor, or either I'm not a tax solicitor. So it's always advisable to go to the tax advisor or tax solicitor who can help you out. But
okay,
yes, there is something about 40%. Yes, I do remember.
Okay. And my other question is like the will be effective immediately or take some time to be effective? Like you should write like 1 year before this or something, or just once you write it, it's like immediately effective?
It is immediately effective as long as you have a 2 witness and your executor, the 2 witness sign it and you sign it, is instantly it will be effective. So it doesn't mean that effective means that it is a valid will. The effectiveness will start once someone die.
Okay, that's fine. Right. Thank you. It was like a great presentation. Thank you very much.
Thank you. And just to highlight here, we'll have accountant and another tax-related solicitor coming in the next few weeks. Thank you for that. Another question from Mohammed Askar, please. Muhammad Askar, please.
Hello. Yeah, I have asked the question and I got the answer. Thank you very much for that helpful webinar. Thank you.
Okay.
Thank you.
So we have here another question from Newcastle. Okay. It's not here. Okay, so another question from the Facebook page now. They said that mean if the property is worth £270, it will go directly to the wife or the husband without anything going to the children. Is that right?
That's right. If it is less than 200, up to £270,000, whatever the property you have, it will go straight out to the surviving partner. All right. And after that, whatever is left, from that left, 50% again go to your surviving partner, and remaining 50% will go to your, will be equally divided among the children.
But again, question here, your will override any other laws in the UK. So in this case, there's no a matter of conflict here. So if your will is saying only my wife, for example, taking only 50K or whatever, in this case, this is what will happen, not any other laws.
That's right. There'll be no conflict.
Another question here in the Facebook, if for any reason I have written in my will something related to outside the UK for giving money or giving some sort of this, does that help them getting visa to come here to apply or to do something, or this is not related to any Home Office regulation?
I didn't get the question.
So if the executor of one of the beneficiaries from outside the UK.
Beneficiary, not the executor, you meant.
Okay, so in this case, that would help them getting a visa, or this is totally irrelevant?
No, it is totally irrelevant, because it's all about, it's not in the United Kingdom. It's not like one property, you divide it in the middle and then you give it to the others. It doesn't work like that. So what will happen if someone left a property and said that from this property, I will give the beneficiary. So what will happen? The executor will sell this property, and the profit and the money from there, they will give the beneficiary. Obviously, beneficiary doesn't need to come to the United Kingdom to get this money.
Okay, another questions about the children. Before being 18, looking after themselves, in the will, would be I able to include who would look after my children? And because there is something related to the safeguarding, and the local authority or whatsoever would be looking at the welfare of the children, and it's there will decide if your will would apply, unless they are convinced that the one that you allocated to look after your children is safe and this stuff. In this case, your will not apply. Am I right in this, or?
Yes, you're right. You're right. You're right.
So in this case, okay. So if a property and two mom and dads died within it, and then the children here, they will inherit everything, or we have to find someone as a guardian or something like that?
So what will happen in this type of situation? If the court will appoint a legal guardian, all right? Yeah. So once the court will legal guardian, obviously court will try to find someone from the family, like maybe uncle or grandparent, if they're surviving, they will ask to them whether they're happy to be legal guardian for these children. All right. Yeah. And obviously the court and local authority, both of them work together to find it out whether the person who they are selecting as a legal guardian is a sound mind, and whether they're able to take care of these two children or not. If the court and the local authority is very happy that yes, that person is a sound mind and they can take care of these under 18 children, they will generally they will select that person as a legal guardian. But if the case is not that, right, then the local authority will find someone who will appoint as a legal guardian.
Thank you. Last question, because of behind the time we have to. Last one, just personal advice for all your audiences, because we have a large number of audiences on the Facebook as well. So now in one yes or no, would you advise everyone to do a will or not? Would you advise anyone to go to a solicitor to make the will or not, please?
Okay, my advice is for we do not know actually when we will die. So everyone earn money and we have a wish how you want to split your property. So it's better, it's always advisable. It's not always, you should actually, everyone should make a will, because it's not a permanent thing. So you can change your will as you wish. As long as your circumstances change, you can make this will. You can amend, you can make another will according to wish. So once you make another will, all old wills will be invalid. That will not be effective. So that's why I'm advising everyone, if you want to give, if you do not want to follow the intestate rule of the United Kingdom, if you have your own wishes to give property to beneficiaries, you make a will. In relation to the solicitor, yes, because if you make your own, draft a will or write a will, there's a possibility that you might do a mistake. But if you're very well prepared and you are confident that you can do it, you can do it. But it is also advisable that you go to the solicitor, because solicitors generally do not charge that much money until it is complicated. Say for an example, you have 500,000 of property. The solicitor might charge you for £500 to make a will. So only for this £500, you are thinking about £500,000. So it's worth it to spend that £500 or £300 or £200, give it to the solicitor who will make sure that the will is valid and no one will challenge, and your wish according to your will is effective.
Thank you for listening, and we hope to see you in the next session. Don't hesitate to follow us on our social media platforms as seen on this screen. For more updates and information on the Egyptians Together Union, please visit our official website on www.egyptianstogether.com. Also, for any questions or queries, please contact us via email on egyptianstogetheruk@gmail.com. Also, for more videos, please subscribe to our YouTube channel called Egyptians Together. Thank you for listening, and we hope to see you in the next session.